May it please
Morning. Mr. Dingley, Miss Broadfoot, just a reminder, we're being live streamed. There is an anonymity order. I know you're very aware of that. Can I just counsel everybody to be extra careful about referring in open court to any information that might have the effect of jigsaw identification? I don't think there is going to be any necessity, for example, to make any geographical references to the part of the country where the school is. I don't really need to remind you that we've got pupil A being referred to as pupil A, her father as the father, and the school as the school. But it's very easy when you're reading out documents in particular sometimes to fall into a trap. So I hope you'll forgive me for making that little reminder at the beginning. Yeah, thank you very much. And thank you for your helpful skeleton arguments, which of course we've read.
Thank you. Just to reiterate, I also here with my learned friend, Mr. Butler.
Yes.
Is the court familiar with all the facts of the case, or would you like me to give you a brief summary?
No, we're familiar, thank you.
Can I just also check that you've got all the documents? So that would be a authorities bundle of 394 pages PDF, a supplementary bundle of 286 PDF pages and 284 typed pages, as it were. And then also a core bundle of 120 PDF pages and 170 typed pages.
Yes. I'm working off hard copies because when we get a situation where the PDF numbers do not correspond with the hard copy numbers, I tend to find it's just more confusing and takes more time for the court to keep jumping between the two. So I'm not criticising anybody, but it's a great shame that the numbers don't correspond.
With that, in terms of my submissions, I'll deal with ground one, which is the weight to be attached to the TRA decision in light of the legislation.
Yes.
And then I intend to take grounds 2 and 3 together effectively as one, because they cover the same point,
Yes.
less, which is the collateral attack doctrine. And then Ms. McLaughlin will cover ground 4, which is the res judicata privies point.
Right.
With that, I'll start with ground 1. That being obviously that the Upper Tribunal reached a conclusion which was plainly wrong or alternatively failed to take into account material considerations such as the significant weight to be applied to the TRA decision which disproved of the conclusions reached. If I could take the court to page 72 of the core bundle, what we're looking at here is effectively the various excerpts from the Upper Tribunal when they were looking to assess the weight to be attached to the TRA's decision. Mm-hmm. So in particular, you've got paragraph 67 to begin with. Does the court have sight?
Yes.
And what we have there is the effectively decision is what is the status of the TRA decision? Well, the Upper Tribunal said it's evidence of what was said at the hearing and of what the TRA panel decided and why it decided as it did. It represents no more than that. The Upper Tribunal must give findings of the TRA panel appropriate weight, just as it must give appropriate weight to the barring decision and to all the other evidence before it. Our task is to make our own assessment of the evidence before us to decide whether the barring decision was based on a mistake of fact. And then if I could turn you to...
Before we move to anything else, do you take issue with that approach?
Yes, to the extent that, when I'll show you the other excerpt, there's no quantification of what that weight is. Yes. It's not enough to say we give it weight. what is the context of that weight in light of the factual determinations that it makes? For example, where pupil A doesn't attend a hearing or give any explanation as to why they did not attend the hearing, or indeed give an inconsistent account, that is a matter of evidence that has to be weighted in the context of the evidence that the tribunal is considering. That's just one example, of course. Another example would be, why is it that we don't have any evidence of any alleged pictures that are alleged to have been provided to the police, for example? Why is it the case that there's inconsistencies between different accounts? None of that is assessed within the Upper Tribunal's assessment of the evidence that it heard, or indeed both written or oral.
But the first point you make about the fact that the girl didn't give evidence in person,
Yes.
as you go through it, I'm sure you'll point out, but there is reference made to that. They did understand that, didn't they?
They said it's for various reasons, but they don't talk about why they don't at all talk about the inconsistencies that were reached. Why it is that pupil gave an inconsistent account. There's no explanation for that, nor is there any explanation as to why that particular individual chose not to attend, notwithstanding the fact that they were over the age of 18 at the time, so an adult.
Right.
And in my submission, that is material. When you're dealing with an inconsistent account, given that there's only two quote-unquote eyewitnesses to the substance of the allegations, which is that there were kissing, cuddling, and messages exchanged between the two parties. The only two people who can give an account of that are XYZ and pupil A.
But are you saying that if they'd gone into that type of detail on those as examples you've just given, that, as my lady was asking, paragraph 67 is appropriate? That if they had done that additional part, in other words, engaged with the reason why the girl didn't turn up, the reason why there may or may not have been pictures and so forth.
My lord, I think it goes a little bit further than that. I think
No, it's
in
just
terms of
question,
that in terms of that paragraph, because if you look when I get to it, if you look at the legislation, so that's Schedule 3, Section 16(3) of the 2006 Act, and just to remind the court, that's at Authorities Bundle tab 5, page 16. What you have there is effectively a provision that says you, as someone who's effectively being investigated by the DBS, can't make representations to say that the decision is wrong. And why that's important is it then lists a series of regulatory bodies who are effectively saying, these decisions, we trust them. Therefore, you can't make representations that what they decided was wrong.
Well, isn't it slightly narrower than that? What paragraph 16 does, first of all, is to create a general rule that a person must have an opportunity to make representations in relation to all of the information which the DBS intends to rely. And then there are two exceptions to that general rule. We're not concerned with the first exception. And the second exception is the opportunity to make representations does not include an opportunity to make representations that findings of fact made by a competent body were wrongly made. So at the stage when the person is making representations, Parliament said the DBS isn't going to get dragged down the rabbit hole of whether or not the findings of a competent body were correct or not. But the effect of paragraph 16(3) is not to say anything about the weight that is or isn't to be given to the finding of a competent body once you're in the Upper Tribunal.
I don't think that's quite right, because remember, the only recourse one has against a decision of the DBS is obviously an appeal to the Upper Tribunal, and in terms of how that works, you first need to get permission.
Yes.
So if you were to say, for example, let's just think of the norm in this case. Usually people who are investigated at this level are unrepresented, so they might still make representations to the effect that the decision from that competent body is wrong, and therefore that's effectively ignored. They can't then take an appeal to the Upper Tribunal to illustrate an error of fact or error of law, to suggest that that decision was wrong.
Well,
Because
is
if
that
you look
right?
at the
Is
case,
that
Is
right?
that
Is that
right?
right? Suppose that the, let's say, a different case from this. The Upper Tribunal makes this decision before the DBS decision, all right? And the Upper Tribunal says, we find proved on the balance of probabilities that there was some improper conduct by the teacher. The complainant then retracts everything and confesses that it was a malicious allegation made up to get back at the teacher for some perceived slight. On the back of that, the teacher appeals the TRA decision to the High Court, which I think is the right route of appeal. And the High Court says, well, in the light of all of that, the TRA decision was plainly wrong and we're going to overturn it. Those circumstances, surely the teacher would be able to appeal the DBS decision on the basis that that decision was wrong.
depends when the decision is made, of course, because you might lose the opportunity to make that appeal.
Of course, but suppose that the appeal is heard and the DBS appeal to the Upper Tribunal is put on ice until it's decided.
Well, of course, at that stage, yes, you could bring that new evidence before the Upper Tribunal to show that there was an error of fact or error of law mistake, effectively.
Yes. But you would be actually making representations that the original decision of the TRA was wrong, and that's why I'm just testing my lady's approach, which is it's a representation to the DBA. The time for making representations to the DBA has gone, but representations to the Upper Tribunal would still enable you to do that.
Yes, I think the point that I'm trying to illustrate here is not that you can't make representations, but the weight that has to be apportioned to that
Yes.
decision is important. And by virtue of the legislation, look, it's not spelt out in clear terms, but my position is simply that in light of what is said and in light of the identification of particular regulators that are set out there, it's clear that Parliament intended respect for those decisions, and therefore by implication the Upper Tribunal also should have respect to the decisions that are made by those particular bodies.
So does it really amount to this, that the given that the individual concerned is unable to make a representation to the DBS that challenges those conclusions, there is an underlying intention by Parliament that those conclusions should be given particular weight or respect, not only by the DBS, but by any appeal body from the DBS.
Correct.
That's how you put it.
Yes, and also in a case like this, where effectively, as you'll note in terms of how the framework works for the Upper Tribunal, where you've got so much new evidence that, again, the Upper Tribunal is considering the matter, quote-unquote, you could say de novo,
Yes.
looking at all the evidence, it must then at that stage, as I say again, place significant weight upon that, because it's effectively stepping into the shoes of the first decision maker.
Yes. It's a rather odd scheme because on the face of the statutory scheme, the Upper Tribunal is merely concerned with whether the decision was vitiated by an error of law or an error of fact. And normally when an appeal body is doing that, they're looking at what was in front of the tribunal at the time, or the decision maker at the time when they make the decision. And it's a little difficult to sort of fit in the fresh evidence scenario, including the overturning of the original decision, I suppose, of the original TRA decision, for example. It's a bit difficult to fit that into that scheme, but would you say that the function of the Upper Tribunal is wide enough to enable it to say, you got it wrong even though you didn't know you were getting it wrong at the time on the material before you?
Potentially, yes.
Yes.
I think that's a rather tricky one to sort of shoe in, but I think.
But isn't that the general trend of the authorities, that if there's material before the Upper Tribunal which just wasn't considered by the DBS, then the Upper Tribunal is free to make a different decision and to say DBS erred in fact, because in the light of the evidence we've heard, which wasn't in front of the DBS, it's clear the DVS got it wrong.
Yes, of course. If you look at the older authorities, obviously that didn't apply, but as things have moved forward, that is clearly the case.
Yes.
I'll obviously get into the point about the collateral attack in point 2, which is basically hearing of the same evidence again. But,
yeah. But this is on the assumption that grounds 2, 3, and 4 are wrong, and that you're just looking at it on the basis that it isn't a collateral attack, but just looking at the statutory scheme, as I understand it.
That's correct. It's a distinct point.
Yes.
I was going to take the court through what's effectively the original decision to bar and then the barring process decision, because that underlies the rationale as to why the decision was made.
Yes.
But if you don't necessarily feel I need to do that, I'm happy to just move on.
I'm very happy for you to do that.
All right.
Sorry to interrupt again, Mr. Dingley. Before you move on, can I just ask you a question about, so to see whether I've understood your submission?
Yes.
You seem to be saying that the Upper Tribunal was obliged to give significant weight to the decision of the TRA. But what if, as here, the Upper Tribunal analyses the decision of the TRA and says it just doesn't stack up? Are they still obliged to give it significant weight, or can they just say, we don't agree with this?
Does it not also depend about the context of the attack of that decision? So, for example, if it's clearly predicated on, for example, fraud or identification of, let's say, for example, the decision says, we find to reasonable doubt, which is the wrong standard, that this particular allegation doesn't stack up on the evidence.
Yeah.
I would say in those circumstances, it could be argued, and I put it no higher than that, that the decision was wrong, but I don't...
But isn't that the position here? Because there are a couple of, I think at least 2 examples that the Upper Tribunal gives of the TRA apparently applying the wrong standard of proof.
I don't think that...
So the TRA talks about indisputable evidence, for example.
I think the point taken on that, forgive me, but there is an authority that I found that is not before you in my reading last night. It's a case called Waring, and I've got the citation as well.
Yeah.
Pardon?
You bought copies?
No, I haven't.
I didn't know about it.
No, of course you wouldn't. Effectively, what the principle behind that is that what I think that sorry, let me just rephrase what I'm trying to say. Effectively, what the criticism is brought in this case about the evidence is that effectively that old adage, the more serious the allegation, the greater the evidence that you need to bring in order for that to stand up effectively to scrutiny. Now,
what's the enhanced civil standard?
Yes, the enhanced civil standard. Now, of course, the case that my learned friend cites is a 2023 decision, which postdates the decision which was made by the TRA. At the time, that enhanced standard, in my submission, was appropriate. The law had not changed at that particular point in time. So
yes, but there's a declaratory theory, so the law always was as it was declared
before.
to be in the 2023 decision. So if looking at it through the lens of the 2023 decision, the TRA applied the wrong standard of proof, well then they applied the wrong standard of proof.
That's, of course, if we get that far. My submission is that they didn't apply the wrong standard of proof. It's not evident in terms of their decision that they made that they did do that.
Right.
It's obviously for my learned friend to convince you that that was the case. My submission is that what you're looking at within that decision is not in itself sufficient to determine that they applied the wrong standard or the enhanced civil standard for that matter.
But I think just moving away from the facts at the moment, or this particular case, I think we have to think about this in terms of first principle. And I think that the point that my lady's been drilling down to, and certainly something that would help me, just suppose that the Upper Tribunal is faced with exactly the same evidence as the TRA, and there's no question of the TRA having applied the wrong standard or anything else. The Upper Tribunal just disagrees. They look at exactly the same evidence and they think, we don't like this decision. We simply disagree with it. Can they substitute their own views of the same evidence for that of the TRA? That seems to me to be the $64,000 question in a case like this.
My submission is the answer is no. because that brings the entire justice system effectively into disrepute, because you have two conflicting decisions on the same fact, same evidence.
But that's the abuse point.
Yes, has that got anything to do with ground one? That's why I appreciate it goes on to other grounds, but what about the ground one point? Is it precluded by your point under ground one or not?
Sorry, if you could just clarify.
In other words, the scenario that my lady's put to you, that effectively you've got a decision, for example, in this case of the TRA, saying X, and on precisely the same evidence, the Upper Tribunal would come along and say, well, we've seen that, but we disagree with it.
With respect, my lord, I think that
Correct.
really goes to point two, and I think I'll come back to
So
that.
it's not under ground one, then?
I mean, you could contextualise it as part of...
Well, I'm just interested.
No, it's not specifically argued under ground one. My ground one deals with the weight to be attached to the TRA decision, as opposed to looking at it from the perspective of ground two.
But if they're surely, Mr. Dingley, I'm sorry to sort of take you off your course, but surely in that scenario they're not attaching any weight to it at all, because they're saying, well, we pay lip service to it because they've made this decision in favour of the teacher, but actually because we disagree with it, we're not going to afford any weight to it at all.
Well, as I said, the ground one is arguing about the weight, and you just said that they're giving lip service, but there's no, as I said, there's no quantification of the weight to be attached. They're looking at, as I said, the particularities of the factual findings and making assessments on that. That's the criticism that I bring under ground one.
So ground one is simply that on this occasion they got it wrong.
Yes.
I see. It's not really a matter of principle in that sense.
No, the principle goes to the weight in light of the legislation and where that actually goes in terms of viewing it from how it's set out. What weight do you apportion that in light of how the regulator is seen by Parliament?
So you're not really taking the point, well, if the teacher is precluded from challenging findings of the TRA, that there's some gross unfairness, if you like, of the Upper Tribunal not being affixed with the findings of the TRA.
I think that is a point that I'm trying to make, but in terms of the quantification of weight and how you assess that, that's in light of what you've just identified. So because he can't...
But it's still a matter of weight. It's not that they are obliged to, as it were, not challenge it.
No, because if you look at the legislative scheme, as my learned friend outlined in her skeleton,
Right,
it does just deal with how it is at first instance. For example, here you've got an administrative decision maker that's dealing with submissions.
Sorry to press you on this, Mr. Dingley. I just want to be sure I understand your submission. Is the Upper Tribunal entitled to give the weight to the TRA's decision which it considers appropriate?
Yes, but that it has to give it high regard in the sense you can't give it...
Well, hang on a minute. That answer means no, doesn't it? Because normally when an administrative law decision maker has to give weight to something, the amount of weight, the significance which it attributes to the thing it's got to give weight to, is a matter for it. So what I'm trying to understand is whether you say that principle applies here, or whether you're saying some different principle applies. In other words, it's got to give some kind of special or particular weight, and if so, what do you rely on in support of that proposition?
The particular weight question is dealt with by virtue of the fact that the person charged with the investigation as such cannot challenge the decision, so therefore it has to go both ways.
But it's not, you say go both ways, but you don't say it ties them.
It doesn't. It can't, because that's not what the legislation says.
Okay, that's fine. Yep.
I'm just saying by implication you have to afford it greater weight.
Yes,
Yeah,
I understand. But it doesn't preclude you from
No,
going behind
because
it if you choose to do so.
No, because I accept that that's not what the legislation says, and I find it very difficult to convince
Sorry,
you
I thought
otherwise.
there might have been an argument.
Right, that's very fair.
fine.
Sorry,
Yeah.
so by implication, the Upper Tribunal has to give it greater weight. Greater weight than what?
Then just saying effectively we acknowledge the decision and that's that, which is what they did here.
Yes, in fact, well, that's presumably why it took us to 67, which I was
Yes.
just slightly curious. It's that middle part where it says it represents no more than that.
Yes, if they
You say
went...
that was obviously they're not giving substantial, greater, whatever you'd like
Yes.
to call it. Yeah.
if they had gone further, I think I'd be on difficult
In
ground.
other words, if they'd actually said, well, great weight, however,
Yes.
then you would have said, well, that's not a point I can make.
Yes.
Appropriate weight begs the question of how much weight is really what it comes down to.
Yes.
Okay.
So what I was also going to do within the context of this decision is, as you'll see from paragraph 128 again of the Upper Tribunal's decision, which you'll find at page 82 of Articles, and that's PDF 85 as well. So here we have effectively the finding of the Upper Tribunal, which says that we're not bound by the TRA's panel's findings, but we should have regard to them and give them weight as appropriate in all circumstances. And then they go on to say the question that we need to ask here is whether the TRA panel was entitled to come to the findings that it reached on the evidence before it, but rather anything in the TRA decision demonstrates that the barring decision was based on any finding of fact that was mistaken or wrong.
I'm so sorry, it's my fault, Mr. Dingley. I missed the paragraph reference.
It's 128.
128, thank you so much.
Now, in terms of quantifying or understanding this assessment that the Upper Tribunal comes to, there are effectively two things I'd like to take you to. The first is the original decision to bar, which again is in the core bundle, which you'll find on page 98.
Sorry, just before going to that, I'm not trying to interrupt. On 128, do you say that's right or wrong, what they've said at 128?
I don't say that that's wrong.
They appear to say that give it...
I mean, that is the test, but I think the
Yeah.
difficulty here, let me just quantify that further, is that where they're looking at it effectively, quote-unquote, de novo, they're looking at it fresh. So really the test about whether it's mistaken or wrong, yes, it's looking at it whether it was wrong or not, and that's looking at it from the context of what is the new evidence that demonstrates that it's wrong, I think.
Well, I thought aren't they bound to look at whether it's wrong, because isn't that mistake, as it were?
Yes.
Isn't that the test that they got to set themselves under legislation? I thought.
Yes, no, that's sorry. I think I've maybe muddled my submission.
They're not asking themselves whether the TRA decision is wrong. They're asking themselves whether anything in the TRA decision shows that the barring decision
Yes.
was mistaken or wrong.
Yes.
That's a different issue.
And aren't they obliged to do that? Isn't that's
Yes, that
how
is
they have to get into
their
the situation.
raison d'etre, as you could say.
Yeah.
So
that is correct, as it were.
yes, that is correct.
All right.
If you just bear with me. Yes, so if I could take you to page 99, the call bundle, which is the original barring decision. And it's effectively that first paragraph under the bold heading, which is for more information about the relevant conduct, please visit our website. So in respect of this particular point, what I'm trying to illustrate here is these are the factual findings that the DBS decision maker made. In particular, I'd highlight the fact there was an identification of sexual interest in teenage girls, that there was a finding that XYZ had engaged in sexual activity with a 16-year-old pupil by kissing her on 4 occasions.
That seems to be the essential difference between all of this, isn't it? Whether the kissing took place or not.
Sorry.
That seems to be the essential difference between the various decisions in this case, isn't it?
Yes.
When you boil it down.
And also, of course, that she would cry and that there was
But the
contact.
essential part was to do with the kissing, wasn't it?
Yes, and that obviously underlies the sexual interest, which is what the
Sure.
DVS are particularly interested in. Now, if I could take you to what's known as the barring decision process, which is the underlying rationale that the decision maker uses in order to come to those conclusions. So that starts in the supplementary bundle on pages 103 to 119. Now, where it starts becoming particularly important is on page 106. So that's the allegations or circumstances. So if I could take you to, for an example, it's the fourth from the bottom paragraph. It starts with the name of the pupil, repeated.
Her story to police.
Yes. And stated that they had discussed being found out and they would deny any wrongdoing, but also that if it came to it, XYZ would take responsibility. In assessing the credibility of the evidence provided, there is nothing to suggest that Father A or pupil A have any reason to maliciously implicate XYZ in any wrongdoing. There is no evidence that pupil A would have disclosed the relationship had Father A not confronted her. Pupil A spoke as though she felt sorry for XYZ. The evidence provided is therefore considered credible. That is effectively saying, well, there's an allegation made, therefore it is true, on my reading of that. And then...
Well, there's an allegation made, but on the face of it, there's no reason to suppose that it was made maliciously. Therefore, it's true.
Yes, but, I mean, that's a rather troubling position to come to.
Well, aren't they entitled to make those, or those points being made and those points being relevant? Surely each of those is, I'm not saying they're sort of win or lose points, but they're certainly relevant, aren't they?
I'll come to it, but for example, in this case, there was an inconsistent account that was given to police by pupil A, which is fundamental to this entire case in terms of the credibility that's given to her as a witness or complainant. Now, there's no assessment within this particular decision that quantifies or rationalises that anyway.
So when you say an inconsistent account, you mean initially she denied it, and then she said, actually, no, this, that, and the other happened.
So what actually happened is effectively the police attended the address. She gives an account to the police, which is completely different, saying that she met a cousin in town, etc.
Yeah.
The police then go away. She then allegedly breaks down, cries, and tells her father the true account, and then the police are called for the second occasion, and that's when a different account is provided.
Right.
And which is the inconsistent between the first account and the
Yes.
second? But
Correct.
I don't want to be particularly controversial, but it isn't coming purely from a sort of criminal perspective. Doesn't that happen frequently? Not every time, but it quite often happens that somebody who's in that type of situation, if it's true, may give differing accounts for just the reasons that we've got down there.
Of course.
That she felt sorry, and no doubt felt herself partly to blame, possibly. All those kind of natural reactions of especially young girls.
We don't know if that's the case, though, do we? Because we don't know if she was truly upset or the reason why she said she felt sorry for him. There's no evidence of that. It's just effectively...
Isn't it common sense?
Remember, we're not talking about...
Experience?
Plausibility and possibility are two things that courts are often troubled by. It's not implausible that she wouldn't be upset or have felt sorry for him. That doesn't mean that actually is the case. And it's important in the context, if you're looking at criminal proceedings, when someone is inconsistent, it's the right of the accused to challenge that account on the basis of the inconsistency. Now, when you have an administrative decision maker making that same assessment, they also have an obligation, in my submission, to test the two accounts together and say, look, there is an inconsistent account here, but we find it's more likely than not that she was telling the truth. But there's no weighting of that inconsistent account within the context of this decision process.
I see. So your real complaint, of much other things, is the fact that they don't actually grapple with that
yes.
in terms.
So my point, that's what I'm trying to say. Allegation made, therefore it's true, rather than weighting of the fact. They could have said, which I accept, well, there was an inconsistent account. We find it more likely than not that she was telling the truth because she was upset, and that underlines the rationale.
So it's not so much what they've said there; it's the fact that they haven't mentioned that there were these two different accounts and sought either to explain it away or to accept that affects credibility.
Yes.
I see.
The other point being, which is also important in this context, is that. There's obviously the allegation of the relationship generally, which consists also of communicating via a messaging service, and it's alleged that this relationship was conducted by an app that affected disappearing messages. Mm-hmm. Now, rather curiously, XYZ did hand in his phone to the police. It was searched, and nothing came of that, and no evidence that would have been on that phone was ever used in any of these proceedings, nor has any of that evidence ever been provided to the DBS or TRA in this case. In fact, rather curiously, during the TRA hearing, the Father A suggested that there was evidence on a phone, but that he had been asked by the police to destroy it, which again was rather curious, and was perhaps one of the reasons why the TRA didn't find him necessarily to be as credible as perhaps made out. And if one looks at the decision-making process itself, it suggested that they obviously had this relationship, but there's never been any evidence of messages between the two of them at any stage.
But isn't the explanation for that, if it's true, that what was being said was that they communicated on Snapchat? And as I understand it, the purpose of that is that nothing stays in the phone.
I thought that the police could retrieve Snapchat messages.
I don't wish to give evidence on this particular point, but
I mean, so again, is your criticism is that they did again grapple with that?
Well, if you look at if you look at page 111,
yes,
which talks about exploitative attitudes, it says that he contacted her on her 16th birthday via Snapchat. Yeah. No evidence could be recovered from the phone due to this, and there's no weighting of that in the context of this decision.
I see.
I think there is some reference in the passage you were taking us to that suggested that she had the teacher's phone number under a different name on her phone.
Page 805.
Yes. But again, that, in terms of evidence of that, there is none. It's just simply the assertion that that was the case.
So there wasn't anything actually from the phones?
No.
Yeah.
But one assumes that the police must have said this to the DBS, because the passage on page 805 says, post-reps, during the limited investigation, police found evidence of XYZ's phone number stored on A's phone under the name of blah, indicating she was trying to conceal contact with him. So that does suggest that that is something that the police found.
There's no evidence within these bundles or anything that's been before the TRA that proves that particular fact. It's mentioned in witness statements of the pupil A.
All right, there is some evidence to support that.
But remember, the witness statement of pupil A comes later than this decision.
Okay.
Okay, you're making the point that the chronology is important because you've got to look at the evidence that was before the DBS first time round.
Correct, yes. And obviously, as I said, the key notion of this particular part is demonstrating why those findings were wrong. And obviously, we sort of assessed that
Yes.
here by looking at the particular facts that the TRA say didn't happen on contested adversarial proceedings, with greater evidence as well.
So they're looking, the DBS are looking at this purely on paper, without seeing or hearing any witnesses. And the evidence that they have to go on does not include what might describe as hard evidence or independent evidence in relation to any communications, at least, between the two protagonists.
Correct. The other point, which is particularly important, if you just give me a moment, was within the context of this assessment. I'll find the passage in a second, but what was said was that XYZ had effectively accepted the allegations in a meeting with the headmaster. Now, if one looks at the TRA decision itself, it was explored in cross-examination, and effectively what the headmaster said was that, oh no, I said that he accepted it by virtue of his body language rather than him actually making an admission. Now, it's difficult to obviously, you can't make a determination upon why the decision maker from the DBS made the decision that they did, but no doubt if someone was accepting of an allegation, that points pretty much one way on the balance of probabilities, that it's more likely than not that the allegation is true. The acceptance of that, in my submission, and the subsequent TRA's finding that that was not the case, is important because that, again, undermines the acceptance of the allegation.
What did the TRA make of the 2 points that are made on page 805? In other words, the suggestion that the police found evidence on XYZ's phone. Sorry, that XYZ's phone number had been stored on A's phone under a different name, and of the only answer that XYZ gave during his interview was to confirm that his car was a similar kind of car to the car that the father had said he had seen pupil A getting into. Did the TRA deal with either of those points?
So in terms of the car points, yes. So in terms of the allegation, XYZ at an early stage accepted that he'd given lifts to pupil A on 2 separate occasions outside of school.
And that's recorded both in the
They
TRA
dealt with that.
and
What
in
about the first point?
In terms of the phone number,
Yeah.
there was just simply no evidence of it, so they found that that matter wasn't proved.
Okay. Whereabouts do we find the in the one we're looking at, the decision we're looking at, the reference to the head teacher saying that XYZ accepted the allegations?
Just bear with me.
That seems to me to be quite an important point.
Yes,
for
it
you.
is. That's why I said I will come to it. I just have it
Yeah.
in my notes. Just bear with me.
Because it's it seems to me that that's a point where if you're acting for the DBS and it's said, well, when confronted by somebody in authority, he accepted that he'd behaved in an inappropriate way towards a pupil, that's quite a powerful point. If the person who is supposed to have been the source of that information then says, no, that was an inference I drew from the fact that he looked shifty, it does put a very different complexion on it.
I can just bear with me.
I mean, halfway down page 105, before the gap, the penultimate paragraph, there is a reference to something that XYZ stated during an interview at the school, that things had happened
Yes,
that he did
that's-
not
that-
elaborate.
that's-
Is that it?
Yes, that's the point.
Right.
So things had happened. So if you look at then the decision, it says he partially accepts that things had happened. So there's a reference to that in the original barring decision itself, the paragraph that I took you to at the start
Yeah.
of my submission.
So what's the reference to the house in that sentence?
Pardon?
Well, so if you go halfway down, page 105.
That's the school.
Okay, that's the name of the school.
That's the
Sorry,
name of the school.
I hadn't picked that up. Thank you, that's very helpful.
And if I could just...
So just so that I can understand, the source of the information, halfway down
Yes.
105, is from the headmaster?
Yes, so effectively what happened was the headmaster interviewed pupil A,
Yeah.
father A,
Yes,
and
no,
XYZ on 2 occasions. On the occasions of pupil A and father A being interviewed, they were both of those interview notes effectively were shown to them and they were able to sign them off. In XYZ's case, he just effectively wrote those notes himself and then didn't allow XYZ to view them and effectively said, quote unquote, you're dismissed by. And then on the same day, which my learned friend will address you on in terms of the privies point, makes the reference to both the TRA and the DBS on the same day,
But
on the same evidence, in fact.
The actual statement there, where it says that during the course of the interview, in quotes, things had happened.
Yes,
But no
that's
elaborate-
in the TRA bundle itself.
Yeah, was that actually said by the headmaster?
It was said in the notes that he provided to the DBS.
And was that...
And that's before you today.
Yeah. Was that held good in front of the TRA? Or
No, they criticised the way in which that investigation was conducted because he didn't have the opportunity to sign that off to say, yes, I did actually do that. And secondly, when I cross-examined him, which you'll also see in the decision, he said, no, I made that inference from body language as opposed to an actual admission.
So that's just plain wrong, that there's a quote there.
Yes.
I see.
I mean, when you say it's plain wrong that there's a quote, I mean, that is what was given to the DBS. It
Yeah,
was
sure.
wrong as
He
a
was
fact.
told
It's in
that,
fact
that
wrong.
XYZ had made a statement,
Yes,
and that then the source of that information says, well, actually, he didn't make a statement at all.
correct. Yes.
Okay. Yeah.
So, in respect of those conclusions which the decision maker makes, that's effectively the underlying rationale for why that barring decision comes to light.
Yeah.
You then have a TRA decision, and I trust the court has had the opportunity to read that in full.
Yes.
I don't propose to go through that in any great detail other than to effectively summarise the key points from that decision, which are effectively that there was no actual evidence of communication via Snapchat or any other social media platform. There was no actual admission on any aspect of the allegation by XYZ. This was assumed on the basis of the headmaster's interpretation of what he thought XYZ's body language was during a effective no-comment interview. There was a wholly inconsistent account of pupil A's account about what was alleged to have happened without any explanation for why she had altered her account about kissing and cuddling on one or more occasions, nor why she had chosen not to attend the hearing. Notwithstanding the fact by the time that hearing came to be, she was over the age of 18 and an adult. And, of course, the protections that come with any TRA hearing in terms of special measures and so on and so forth. There was an absence of any actual pictures of the alleged conduct. There was no actual evidence of XYZ's number being stored in pupil A's phone. And there was no evidence of any sexual motivation for the actions that XYZ took, namely giving pupil A lift on 2 separate occasions outside of school. My key point in the context of ground 1 here is that there's no underlying appreciation of the weight to be afforded to those factual matters in the context of the decision and the body that makes that decisions when rationalising its findings, hearing the evidence for a second time, or making a decision for itself about whether he should remain on the barred list.
Well, hang on, you say that, but we've seen the passage in the Upper Tribunal's decision where it says they're going to give the TRO's decision such weight as is appropriate, and you said that wasn't wrong in law.
Yes, but it needed to go further in light of, as I said, what I said before about the significant weight that should have been attached to it, and in light of the factual findings that it's made. When you contrast the underlying rationale behind the DBS process decision.
In other words, when you look into it, even granularly into detail of it, they actually not only should have given it much more weight, but actually were not entitled to go behind it.
Yes, if you look at what evidence they actually had, which was only a repetition. As I said, I'll address this in ground 2 more substantively, but it was just simply a repetition of the same case again on less evidence.
Well, they fundamentally, I think they also listened to the teacher, didn't they?
What, the Upper Tribunal?
Yes.
Yeah.
They heard evidence from...
Yeah, it was just, yes, my point is... It's
and
the
fundamentally,
same
they didn't agree with the assessment of credibility.
Yes, but it's the same evidence again. He just effectively repeated his statement again.
So do you say they weren't entitled to make a different assessment of XYZ's credibility from the assessment that had been made by the TRA?
Correct, because it's on less evidence than the other tribunal heard. It'd be different if there was new evidence, which, as I said, I'll address this.
Well, isn't that a slightly different point? There's 2 things, aren't there? There's the underlying evidence.
Yes.
And when somebody gets into the witness box, for example, in this case, he was just giving evidence, their credibility. I appreciate it. In part, it's linked because obviously somebody's credibility is in relation to underlying evidence, but it is a separate issue, isn't it?
I don't think it is where someone just repeats the same question, the same evidence again, because of course 2 tribunals can come to 2 separate conclusions in the same evidence. As you know, where there's a hung jury, for example, you might have a retrial, and it might be just repetition again.
So what's wrong with that? The fact that they have...
There is less evidence than they heard on the first occasion. It would be different if the same witnesses were called again, and they made a wholly new decision premised upon that, but they didn't do that, because as I understand it, the DBS's position is not to call any witnesses.
But fundamental, why couldn't they make a different assessment of his credibility?
Because they're hearing less evidence than was before. It's the same repetition of the same account,
okay,
with less evidence. And just in terms of that greater significant weight point that I illustrated to the court earlier, in my submission there's also the case of B and DBS, which in passing does effectively, in my submission, provide authority at paragraph 70, so that's in tab 19, page 132. About the weight to be attributed to the decision effectively of the TRA body. I think it was previously called the NCTL.
Sorry, can you give me the reference again?
Yes, it's tab 19, page 132, paragraph 70.
So this is the decision of the Upper Tribunal?
Yes. And obviously there, what the Upper Tribunal highlights is that the DBS and, in my submission, the Upper Tribunal, as the decision maker, have to take into account the full range of findings of fact made by the NCTL. And in my submission, what that goes to here is what I have summarised as the effectively 5 key points about the factual summary of what the TRA found in the context of making a decision when stepping into...
So where does the paragraph 69 get?
Paragraph 70. 70.
Oh, sorry, 70. Yeah.
Yes.
What does paragraph 70 get, which is of relevance to this?
I'm just talking about, in terms of authority, about the way in which the Upper Tribunal has to give weight to particular findings of a teaching body in this context. So looking at the full range of factual findings, so not just looking at it from an isolated perspective, but all the factual findings that were made So that's, as I said, that what that point goes to is that the 5 points that I say in summary that they made when contrasting with the DBS process decision in order to demonstrate that there was a mistake of fact and why it was plainly wrong.
I'm not really sure how paragraph 70 takes us any further. It's just a comment on what was available in that case to the DBS and what was available to the NCTL.
Yes.
How does it help the analysis here?
In terms of it just demonstrates that the full range of factual findings have to be taken into account. It goes no more than that. It's just effectively a side point.
But it doesn't enunciate a legal principle. It's just a description of what happened in that case.
My lords, unless there is anything further you wish to probe me on ground 1, I intend to move on to ground 2.
Can I just ask you a point which, before you move on, because otherwise I'll get this just myself. There is, in the DBS procedure, there's a way in which if you've got a decision of the DBS, and in fact the DBS, I think, pointed out themselves in the course of their decision, you can go back for a review, can't you?
Yes.
It's probably perfectly obvious why it could that not have happened in this case?
I think the timing was perhaps the issue.
I see, only because it said, in fact it's page 100, it's noted the TRA currently undertaking investigation, etc., not expected imminently, obviously they could get on with their decision, and they talk about if any new information comes to light, then a review can be requested.
Yes, but as you may have seen from previous authorities, or indeed the experience of this court, usually the context of a review may occur after a decision has been made sometime later, and then someone asks for a review in light of effectively a psychiatric report to say that they don't have sexual motivation or they've undertaken some sort of...
Well, what about in this
training.
case?
In this case, the problem was the DBS made a decision, of course.
Yes.
Then that was appealed. It was then listed...
Well, you wouldn't need a review if there hadn't been a decision.
Yes.
Right.
Well, effectively, we were at the point at which a hearing was going to be listed at some point after that decision.
All I'm asking is, was there something precluded you going back for review? I'm not saying you should or you shouldn't have done it.
I think there were financial considerations with that in mind.
So you could have actually...
Yes.
Yeah, I'm not saying they're unimportant, but there was a mechanism here that you could have gone back to the DBA and said, look, you've got this. Someone's now actually listened to the evidence and heard it and made findings of fact. We'd like you to review.
Potentially, yes. I think, as I said, timing of this whole...
No, I appreciate it.
Was a bit of a problem because, as I said, the decision had been made and an appeal had then been filed. So the appeal had already been filed at the point at which the TRA decision was made. If that makes sense.
I mean, I just wondered if you might have been in a stronger position in the sense that, because the DBA, as I understand it, at that level, doesn't hear evidence, live evidence, but on written evidence.
Of course.
And you could have gone back and said, it's only a tactical matter, well, actually somebody's
heard the evidence,
listened to the evidence, made findings of fact on it, you ought to do something about it.
That, of course, is important, but let's also just think about the context in which these two bodies interact with each other. You'll note from some of the decisions, and again, my learned friend will address you on this, the two bodies do talk to each other, so they were no doubt aware of both things going on at the same time.
Sure.
So, in effect, even if he had requested a review, they were no doubt aware of what had happened at the TRA, and therefore were aware of what was going on in that respect. And
but that's not going to take them anywhere unless there's something that they're being asked to do about it. I mean, I would have thought that the DBS, even if they were aware of it, would say, well, that's something that's going to be mopped up by the Upper Tribunal when they come to deal with the appeal.
Yes, but as I go back, yes, there could have been a review. One could have suggested.
I see. Okay. No, just wondering, just out of curiosity.
Yes. So yes, I intend to move on to ground 2 unless there's anything further.
Yeah.
So this ground, of course, is whether the Upper Tribunal made a material misdirection of law on a material matter when it held that it was open to find facts, particularly those at 142 to 143, which you will find on page 84 of the core bundle. So that's effectively the factual findings that there was kissing, hugging, sexual interest of the Upper Tribunal's decision. And that occurred after considering almost identical evidence to the same standard of proof of the earlier TRA decision. Yeah, it's 142 and 143, page 84. So in this respect, the appellant relies upon and invokes what's known as the collateral attack doctrine, which, as the court may be aware, is a species of the abuse of process.
Yeah.
The two authorities that I'll take you to are the case of Hunter and Mundik-Bozic, obviously the latter being more factually similar scenario to the one faced by XYZ in this case. If I could take you to the case of Hunter, so that's tab 15 of the authorities bundle. And page 68. Paragraph B. Obviously, in Hunter, there's a distinction to the instant case because there you're dealing with a criminal allegation and civil proceedings which follow a criminal allegation.
Well, criminal conviction, not
Criminal
allegation.
convictions. So that again, it's slightly different in terms of dealing with two civil bodies as we have in this case, but no doubt the principles in my submission are the same. I will also take you to the bottom of page 68, so that's paragraph H.
But just wait a second. While we're on paragraph B, well, Diplock says the abuse of process which this case exemplifies is the initiation of proceedings in a court of justice for the purpose of mounting a collateral attack on a final decision against the intending plaintiff, which is being made by another court of competent jurisdiction. Now, who's initiating the proceedings here for the purpose of mounting a collateral attack on something else?
Technically, it's the appellant because he has filed or lodged the appeal. I think the key point, as you'll note from the way that the case was conducted in the Upper Tribunal, my submission was that it was inappropriate for effectively a repetition to take place. My learned friend, of course, pushed the court the other way, and they decided, of course, that they were entitled to hear evidence, and did. My position is that that shouldn't have taken place.
But they shouldn't have heard evidence.
Yes, and the position was effectively they heard evidence, you could say, under reservation, and made that decision in substance later, having heard the evidence.
But this is, the situation in this case is poles apart from what's described in Hunter, because in Hunter you've got a criminal conviction, so a jury is sure that the intended plaintiff did the bad thing, and then the intended plaintiff launches civil proceedings which, for the purpose of mounting an attack on the criminal conviction. Completely different from this case, isn't it?
Not exactly, my ladyship, and the reason for that is this. The DBS's approach to the Upper Tribunal's decision was that you are entitled to go behind the findings of the TRA. That those were the words that my learned friend used. It would not be an abuse to do so.
Well, that's I mean, that is a very different
Yes,
scenario.
it's the
And of course, there
starting
was the burden and standard of proof point.
And also yes, but Hunter is the classic example of collateral attack abuse. I think, in fairness, one has to look at the passage that looks at the earlier authorities at pages 68 and 69 of our bundle, where there's reference, for example, at the top of page 542 in Lord Diplom's speech, to what Lord Halsbury said. I think it would be a scandal to the administration of justice if the same question having been disposed of by one case, the litigant were to be permitted, by changing the form of the proceedings, to set upon the same case again. That's the underlying point of principle. Once it's been decided in a competent forum, and there is finality, you shouldn't be permitted to reopen it. And there are examples of circumstances in which you can, for example, if there's fresh evidence. Your point is, this is Hunter type abuse, although it's not directly on point. It's Hunter type abuse because there has been a decision by the very authority which is tasked with determining whether the teacher has behaved inappropriately. He has been found not to have behaved inappropriately, and therefore it's a collateral attack upon that for the Upper Tribunal to turn around on the same material and say that he did.
Correct, yes.
That's really it, isn't it?
Yes, and I would just add, if one looks at all the authorities, effectively, there's a slight distinction in all of them in that they're not considering identically the same question. That's the distinction in this case. And that is what the Upper Tribunal did on this occasion. I consider exactly the same question. So, for example, in Green and Davis, there's reference to it being a case, this distinction about where it is exactly the same question being asked again, and then it said, well, in that circumstance, it would be different.
So, are you going to take us to that?
Yes, I will. Yes, of course. Just bear with.
Do you want us to look at it now? It's tab 22.
Yes, so that's in Authorities Bundle, tab 22, and it's page 207. Sorry, just bear with me. Yes, so we're looking at paragraph 54, and it starts with "on the other hand." And this is where it distinguishes effectively the case of Colon and Sims.
Sorry, paragraph 54, Roman numeral 1.
Yes, 207.
The issues in the action were different.
Yes. So obviously in Green and Davis, you've got a situation where, on account of disciplinary proceedings, a civil suit is then brought against that solicitor on account of him allegedly being dishonest and using fraud.
Questions arising from the complaint are not identical to those which were before the district judge.
Yes. So that's the distinction in that case.
Yes, because the solicitor in that case was being accused of dishonesty, and then when it got to the disciplinary proceedings, there was a suggestion that he may have given incorrect evidence in breach of SRA principles, but nevertheless honestly. So it was a different
Correct.
point.
Yes.
Are you relying on this case?
Yes.
Because I mean, the conclusion is that paragraph 66. Is that right? Perhaps I've got that wrong.
It's the final sentence, I think, of subparagraph 2 that's against you, or potentially against you. Qualified by the word necessarily. A determination by a civil court cannot necessarily preclude disciplinary proceedings based on allegations which the civil court had rejected. Well, why isn't vice versa equally true?
I think if one looks at Mandic Bozic, we can go into the
Okay.
realms of that a bit more specifically. I think obviously some of the cases that I've taken you to aren't exactly on point.
No.
But
there doesn't seem to be anything particularly in favour with you in this case, in the case that you've just been looking
I
at.
think that the point that I was trying to make, from particularly Green and Davis, is that the court underlines that sometimes where there is exactly the same question being asked, that there's effectively a prohibition on that.
I see. Okay.
But what Mandic Bozic does, which I'll take you to in a second, is set out what's called, you could say, is the test for how this particular line of abuse is supposed to be assessed. So that's at tab 18 of the authorities bundle. And so page 98.
So what are the facts of this case?
This is the psychotherapist, isn't it? There are two parallel bodies, as I understand.
Yes.
Who both, as it were, have some kind of jurisdiction.
In this case, obviously, a stay was sought by the registrant to prohibit the second set of proceedings coming into action, whilst there was already a finding of no sanction.
Yeah, in the
some
first one.
Factual findings in the first occasion.
And this was Mr. Justice Weston, wasn't it?
Yes. And it sets out effectively at page 98 at the bottom, you've got a recitation of 4 principles, of which he only cites the first and fourth of Queen's House. Sorry, the Secretary of State Trade and Industry versus Burstow, so Queen's Old House. And if you look at part 4, effectively it sets out there, if the parties to later civil proceedings were not parties or privies of those who were parties to earlier proceedings, then it will only be an abusive process of the court to challenge the factual findings and conclusions of the judge or jury in the earlier action if, 1, it would be manifestly unfair to the party to later proceedings that the same issues should be relitigated, or to permit such relitigation would bring the administration of justice into disrepute. So that's effectively the test. Yeah. There's no prescribed test as to how far that goes, but it's two general principles that have to be considered here. And in my submission, what you have in our case is that exact situation. He has had an adversarial hearing, had witnesses being called, expended vast sums of money lasting 2 days. Both sides were represented by counsel. You had an independent legal advisor advising that panel, and a regulatory body which has been accorded due status by Parliament for the decisions that it's made, and that's recognised in the legislation itself. Of course, this doctrine also applies in the context of disciplinary proceedings, and you'll find that at paragraph 7 of Mandic Bozic, so that's on page 99. And perhaps more importantly, if I take you to paragraph 45 of this particular decision.
Well, he is wrong about cause of action is stuff, isn't he? Which rather undermines the efficacy of this analysis, but still.
So what is discussed here is, of course, a similar case called Weston. And of course, my learned friend will address you on the privies point in due course, which is effectively your starting point on this particular case. But like in Weston, in this case, you also have two organs of the state. You have the TRA and you have the DBS.
Yeah.
They're both pursuing very similar types of outcomes in terms of findings of fact that X happened, effectively the complaints that are made occurred. That has already been adjudicated upon. And effectively, by virtue of the way that my learned friend for the Disclosure and Barring Service conducted the case in the Upper Tribunal, it was effectively re-pursuing the allegation again by virtue of cross-examination on the same evidence, again, suggesting that alternative findings of fact could be made. And this illustrates that where there are two similar organs, or indeed the same, that is impermissible. And in my submission, this is authority for that position.
Is Weston in the bundle?
It's not.
Well, Weston was a very different situation, wasn't it? That was the company directors case. They were trying to get company directors disqualified by one route or another.
The rationale, obviously,
Yeah.
for this case is reliance upon that, so that's the reason why it's
If one looks
factually distinct as well.
at Justice Mostyn's reasoning, para 47, I don't agree with the argument where the complaint to each body is identical and where the bodies are performing precisely the same functions over the same professions in accordance with common ethical standards. Well, we can see the thrust of that. I certainly can see the thrust of that argument that you can't have a shot at getting somebody debarred under one professional regulator and then go and get on exactly the same material, have another go when you fail. But the DBS has a different function, doesn't it, from the regulatory authority, although they may have common standards and they may have may have a number of aims that are in common. The DBS is looking to the future risks to children and so forth posed at the moment by this person, existing and future risk, I should say. The regulator is concerned with whether their conduct in the past has fallen below the standards to be expected of somebody who is a teaching professional and to determine what sanctions, if any, should follow. So they're not exactly, we're not dealing with exactly the same kind of scenario, are we here?
It's I think the point that I'm trying to make is it's the request of the DBS for the Upper Tribunal to step into the shoes of the decision maker and revisit the findings of fact that are the issue. It's not saying, if we were talking about the proportionality of that decision, for example, which is one of the factors that the DBS can consider, that would obviously be an entirely different argument. But the view that was taken by the DBS at first instance here was these facts occurred.
Yes.
So that's the problem here.
Yeah. But the appellate tribunal is not just limited to a review. What sort of appeal is it to the upper tribunal? Is it an appeal on the material that was? It can't be just. It's not confined to the material that's before the DBS at the time of the decision. So it's a de novo appeal, isn't it?
Yes.
If it's a de novo appeal, surely they can hear evidence and decide it for themselves, whilst paying appropriate respect to the decision that was taken by the other body.
Yes.
Particularly if Parliament hasn't said specifically that the DBS is bound by any findings of the upper tribunal of the regulatory authority.
No, they could have made findings for themselves in terms of whether he should stay on the barred list or not, but the findings of fact to which they rationalise that decision are wrong because they've revisited those facts and made their own determination.
So that's a rather elliptical way, Mr. Dingley, of saying that they were obliged to or bound by the findings of fact that the upper tribunal had made on the evidence before it.
Yes.
And I think you have to say that, don't you? I think you
Yes.
have to say it's an abusive process to seek to reopen the fact findings, possibly in the absence of further evidence that might shed a different light upon them. But in the absence of there being any fresh evidence, the upper tribunal is bound by what the regulator has found.
Correct.
Yes.
But how does that fit with your earlier acceptance that the Upper Tribunal's direction to itself that it shall give appropriate weight to the decision of the TRA was correct?
Again, they don't really go much further than just saying appropriate weight. What they should have said is that, these factual findings have been made. We are not intending to reopen them.
Well, but I thought you accepted that self-direction was correct. I'm just, at the moment, I'm struggling to see how these two sets of submissions are consistent with one another.
Well, the first submission is just, as I said, the approach is about the weight. I'm not saying it's binding. I'm saying it's the approach to the weight that's given to that decision in the context. So that's separate from where the facts are identical and the evidence is identical. I think that's the distinguishing feature. That's a separate argument.
I see.
Does that...
Yeah,
So in other words,
in
a different scenario,
Yes.
we wouldn't be going down ground two path, because you, or if you did, you wouldn't have a very strong case, etc.
Correct.
But you're
All right, I
saying
understand
that
that now.
because
Yeah.
of the facts in this case are
Yes.
identical, or the evidence is identical.
Yes. So that they're two separate. So, if, for example, if the facts were different, or there was different evidence on the second occasion, you would still have to give weight.
Yes.
Proportionate of weight.
Yeah. So this is a very fact-specific type of situation.
Yes.
You're saying this particular
Yes.
one. Okay.
What you're saying really is that you've got to give appropriate weight to the decision, but that is a separate issue. The weight that you give to the decision is entirely separate from being bound by any fact findings that other tribunal has made. And you say that it would bring the administration of justice into disrepute to allow the whole thing to be relitigated again at the appellate level, because it would deprive your client of the favourable findings that were made by another body which is equally competent to assess.
Correct.
And it really comes back to the question I asked you at the very beginning: is it open to the upper tribunal to say, well, we just disagree with this, and we don't like the outcome, and so we're going to make the decision anew for ourselves? And you say no. Can't do that.
Yes. I think, as I said, the facts of this case are fairly unique in the way that it happened. I'm not saying it's completely unique, but it's probably the first time, at least in my experience, that it's happened. And from what I've seen from the authorities, it hasn't happened before.
In other words, we wouldn't be here at all in that sense unless it was literally on exactly the same evidence.
Sorry, I didn't catch what you said.
We wouldn't be here in that sense unless you say it's on exactly the same evidence and you've got a prior hearing which has effectively exonerated on the material part the teacher.
Yes.
Yeah, I understand.
If you look at some of the other authorities...
So in other words, the reason you... I'm trying to understand your concession, as it were, about the matter that my lady was talking about, the approach of the tribe. They may have approached it. The question was, they asked themselves, was correct, but the answer they should have said, well, actually, there's no further evidence here, therefore the amount of weight is such that we should not go against it.
Yes.
Yeah, I understand.
And just to distinguish the CW case, which my learned friend refers to, the point in CW is that there was no substantive testing of the evidence. It was just simply a decision from the TRA, we're not going to investigate this further, and we'll leave it at that. Whereas in this case, you have, as I said, a full-blown hearing.
I don't think, I think in fairness, under ground one, you hadn't, my understanding, hadn't gone quite that far, had you? You hadn't said that the weight was such that they ought not to have gone against it, but you are saying that in terms.
I think
Well,
the
perhaps
ground
you
is
did, but
articulate. Sorry,
no,
my lord.
don't
I
worry.
think the ground is actually articulated in that way.
I'm sure it is. It's
yes.
just I don't think I
Perhaps the
misunderstood
submissions
what
that
you were
follow
saying.
were not perhaps as clear as
But I
I
understand.
would have liked them, but
I don't
the
know why.
principle that I cited in ground one
I'm sure it's my fault.
failed to take. Yeah.
I entirely understand the force of the point that you make about the extremities of the findings of the upper tribunal going much further in terms of the fact findings that they come up with in relation to motivation and so on and so forth, having found that something happened that the teacher was exonerated of by the regulator. I get that entirely. But could the upper tribunal have, on your approach, have said to itself, well, we accept the fact findings that were made by the regulator, and those fact findings include the fact that your client admitted that he gave lifts in his car to the pupil on 2 occasions, including a very lengthy journey, without any apparent explanation for that. And in context, there was no extracurricular activity of the type that might justify such a lift being granted to the pupil. On his own admission in the evidence in the other case, and that in itself is enough to justify what the DBS did.
Yes, but that's not the way that it came to its decision. If you look at both the DBS process...
But you're accepting that in principle it would have been entitled to do that.
Yes, they could have turned around and said...
I mean, it is part and parcel of its reasoning, you see.
But it's not isolated. And
no, it's not isolated. It goes further. It makes much more serious findings.
Yes.
But from the point of view of the appeal, if it's gone further than it needs to, but it's still nevertheless made findings that it was justified in making and would have been open to it, then that might actually affect the disposal of the appeal, might it not?
It might, but my submission is that the rationale behind those findings is so flawed
yes,
that you cannot simply detach those isolated findings on their own from the whole factual matrix of the findings that they make.
Okay.
Particularly given that the underlying rationale for putting someone on the barred list is to show sexual motivation.
Yes.
Which is effectively the whole purpose behind it.
What you say is, if you stripped everything else of the inferences that have been drawn, and you simply had a situation where a teacher on 2 occasions gives a lift to a child in a car without any obvious reasons for that, and the child is female, you can't then infer that that person has got a sexual interest in all female children such that he's a danger to society and should be put on the DBS.
Correct, notwithstanding that those 2 actions occur outside of term time when she has quote-unquote left the school.
Yes.
I'm not saying it's good practice by any means.
No.
Which is why it does all come down to the allegation of kissing.
Yes.
Yes.
And contact, really, as well.
Well, all right, but effectively it's the kissing.
Well, I think the contact is a bit of a red herring because if you look at the nature of what the messaging was supposed to have been, it was simply setting up meetings and I think some of it was supposed to have been offloading about GCSEs and so on and so forth, which is what you might expect if you treat a teacher as a confidant. So I'm less concerned.
Which in itself might be a bit dodgy.
It might be, but
But there's nothing.
I think the kissing is really the
you
more disturbing.
One way or another, you can't get around the kissing. If there is,
yes.
if they're entitled to come to it,
Kissing,
then
cuddling.
you're sunk, as it were. If they weren't, then you may have something else.
Yes. Unless I can assist the court further, those are ground 1 and 2, and I'll invite my junior to come forward and question.
Right. Anything? No?
No.
If it may please the court, our fourth ground of appeal is that the Upper Tribunal erred in law by misunderstanding the application of the res judicata principle and permitting the relitigation of a cause of action which had already concluded. For that reason, we submit that the DBS were stopped from arguing and the Upper Tribunal were stopped from adjudicating on XYZ's conduct with pupil A.
So what's your cause of action that's being re-litigated? How do you define the cause of action?
We're defining our cause of action as the exact facts that occurred.
That's not the facts that occurred are not a cause of action. The cause of action is the basis on which you bring a civil claim in litigation from A against B, such as a breach of contract or something of that nature. So what is the cause of action?
Our submission is that the cause of action is that the facts in themselves gave rise to any inference that could be drawn. So the exact conduct that was referred to both the DBS and the TRA was exactly the same. And for that reason, the cause of action of the two was the same.
But is it right to describe the DBS or the TRA as having a cause of action against a teacher? I mean, isn't the position that they have statutory functions which Parliament has given them and some statutory duties which Parliament has required them to discharge? How is that a cause of action?
So our position is that, as my learned friend outlined earlier, that the res judicata and thus cause of action can apply to disciplinary proceedings, and that the TRA is defined itself as a jurisdictional tribunal. So for that reason, they must have a cause of action to adjudicate on.
Or is it some kind of form of estoppel, you say?
Yes.
Yeah.
Cause of action estoppel.
I can see how you might have an issue with estoppel. I'm struggling with cause of action estoppel at the moment. But anyway, you develop your arguments and we'll see how we go.
Thank you. So as I said, we are specifically concerned with cause of action estoppel today, which applies where both the parties and the subject matter of the litigation are the same in both the first and the prospective second action. And in those circumstances, there is an absolute near bar on litigating the matter twice. And that quotation is taken from R on the application of Mandic-Bozic at paragraph 5A. As I've said, in our submission, the subject matter or the cause of action being the same is evident in these proceedings. The subject matter for both proceedings was whether XYZ's conduct with pupil A established relevant conduct which was inappropriate.
Sorry, what was the reference in Mandic?
Paragraph 5A, which is
Paragraph 5, Roman
Five.
numeral 1? Sorry, no. Where are you?
sorry. So I'm on page 97.
Yeah, so it's 5, Roman numeral 1.
Yes.
Yep.
So the subject matter being the same is demonstrated by the referrals to both organisations. So XYZ was referred to the DBS on the 13th of October 2019 by the head teacher of the school. And page 13 of the supplementary bundle summarises the facts that were referred. And that states, XYZ began a relationship with the year specified pupil at our school. It began in January 2019 with messaging on social media, and from March 2019, lifts were given to the year 11 student in his car to various destinations. On the same date, the matter was also referred to the DBS on the 13th of October 2019. And this is at page 45 of the supplementary bundle.
Yes.
And within that referral, the same language is used when describing details of the allegations of serious misconduct. That's page hard copy 39, where it states XYZ began a relationship with the year pupil at our school. It began back in January 2019 with messaging on social media, and from March 2019, lifts were given to the year student in his car to various destinations.
So your point is that on the same day, precisely the same allegations are made against the teacher in relation to the relationship with the pupil, both to his regulatory body and to the DBS.
Yes.
Yes.
So as you've summarised, exactly the same facts were therefore referred to the TRA and the DBS. And thus it was the same facts, and in our submission, the same cause of action.
But whose cause of action is it? Who's advancing the cause of action? Who's relying on it?
In our submission, the TRA and the DBS are both advancing the cause of action in that should XYZ be prohibited from being a teacher, and should XYZ be placed on a barring list.
Right.
Who referred it to the DBS and the TRA? Was it the school?
The teacher in both, the head teacher in both circumstances.
Right, so why isn't it their cause of action? I mean, normally when you think of a cause of action, somebody is making a claim or pursuing it. The cause of action is surely being advanced by the school against the teacher, who is the respondent to it, and the DBS and the TRA are simply the body that has to adjudicate upon that dispute. So, I mean, you never talk about a court having a cause of action against anybody.
No, but in my submission, the difference is that in the court, it would be an individual who's bringing the cause of action themselves. Whereas with the DBS and the TRA, the school isn't a party to those proceedings.
Right.
They give over their information to the two bodies.
So they're carrying out essentially an investigatory function.
Yes, they have a duty to refer.
Right.
And they refer the information that they have within their power, but they don't go any further than that.
Right. So the school is not a party to the proceedings. Yes. Right.
So as has been said, on the 15th of September 2020, the DBS barred XYZ. And then on the 18th to the 20th of May 2021, the TRA held a 2-day hearing with a panel of 3, a legal advisor and counsel for both sides. The decision was published on the 6th of August 2021, and as my learned friend has already addressed you on, they established that 2 instances had occurred which were giving the pupil a lift.
Yeah.
But in their findings, they did not consider that the conduct displayed would be likely to have a negative impact on XYZ's status as a teacher, or that it would be potentially damaging to the public perception, which is the factors that they consider when deciding if a prohibition order is appropriate. XYZ had already obtained permission to appeal the finding of the DBS before this date, but as has been spoken about this morning already, the Upper Tribunal are not just confined to what was before the DBS. The Upper Tribunal were able to take into account new evidence during the appeal, and it is our submission that at this point in time, the Upper Tribunal were stopped via res judicata cause of action from coming to any different outcome other than the outcome the TRA have found on the facts of the allegation. It is well established that the Upper Tribunal are not limited to asking whether the decision was wrong at the date it was made, but whether it is wrong at the date it is before them. And it is our submission that it was wrong in law for that matter to proceed on that date. That concludes my submissions on the principles of res judicata and how the subject matter is the same. However, for res judicata to be applicable, it must of course be established that the DBS and the TRA are parties, the same parties or privies. And the next part of my submission will focus on how in our submission the DBS and the TRA are privies. As I stated originally, cause of action estoppel applies where both the parties and the subject matter of the litigation are the same in both the first and the prospective second action. And as recognised in Gleeson and Whipple, a party may be bound by an earlier decision affecting another party when there is a sufficient degree of identification or privity. Then page 49 and 50 of the authorities bundle considers this point.
Page
49 and 50.
Thank you.
Page 49 at the top of D states the requisite privity is said to be privity either of blood, of title, or of interest. Our submission today is that the requisite privity is that of interest. And when that case goes on to consider interest, it says at page 50G, I do not say that one must be the alter ego of the other, but it does seem to me that, having due regard to the subject matter of the dispute, there must be a sufficient degree of identification between the two to make it just to hold that the decision to which one was party should be binding in proceedings to which the other is party. It is in that sense that I would regard the phrase privity of interest.
But the example that's given is very different. It's trustees and beneficiaries,
Yes,
where one can immediately see that there's a privity of interest.
yes, it is a very different example, and that's why we'd then be relying on the case which is at tab 16, which is Secretary of State for Business, Innovation and Skills, and Patel. And that case involved a director who had been involved in fraudulent evasion of VAT. And the VAT tribunal had concluded that the director, Mr. Patel, knew there was fraudulent evasion. HMRC, via the Secretary of State for Business, Innovation and Skills, applied to disqualify him as a director, and his position was that he didn't have the requisite knowledge of if he had committed these acts, despite the fact that he'd been disqualified, and therefore litigation was required. So the point that had to be examined there was if HMRC, or the Secretary of State for Business, Innovations and Skills, and the VAT tribunal were the same.
Well, paragraph 29 is your best point, isn't it?
Although it does go on to say, whereas here the issue is to director's knowledge of a complex MTIC fraud has been fully and fairly investigated by an experienced tribunal, and the director found to have had the requisite knowledge, etc.
Yeah, you say it's been fully and fairly investigated by an experienced tribunal, and the issue is whether or not he's fit to be a teacher.
Yep.
And you say sauce for the goose, basically. Right-thinking members of the public would regard it as an unpardonable waste of scarce resources to have that issue relitigated, except that this time it's not a question of requiring him to have it proved against him. He's actually trying to
reopen
turn
it.
Yes.
Well, it's a slightly different situation.
It is a slightly different situation, but yeah, I see the point though.
Thank you. So some other factors in this case that I think are helpful. Paragraph 18, which is on page 78, states, rather more difficult is the question whether the Secretary of State has the requisite privity of interest with HMRC.
Yeah.
And then factors that point towards this Both are or represent government departments charged with the protection and furtherance of the public interest, and both are funded ultimately from the public purse, i.e. from the taxpayer. In our case, the DBS, which, as stated on its own website, defines itself as an executive, non-departmental public body sponsored by the Home Office. The TRA defines itself as an executive agency of the Department of Education, who act on behalf of the Secretary of State for Education as regulator of the teaching profession. They are both, therefore, or represent government body departments, much like in the case referred to. You then need to consider if their function is the same in our submission, and in our submission, their functions are very similar. Both are to protect groups in society, and this is evidence from the texts which support their role. So in the Bundle of Authorities, tab 27 sets out a very detailed document called the Teacher Misconduct Disciplinary Procedures for the Teaching Profession.
Yes.
And on page 330, it states in effect what the TRA's role is, or what they check. And it says the TRA, on receipt of referral, the TRA will check, firstly, if the person's been employed to carry out teaching work in England, and secondly, that the alleged conduct is capable of amounting to unacceptable professional conduct, conduct that may bring the teaching profession into disrepute, or conviction at any time of a relevant offence, and that a prohibition order may therefore be appropriate. Tab 28 describes itself as an advice which panel members should use to help them when coming to their decisions. It says on page 372, this advice sets out the factors to be considered by a professional conduct panel, which is an independent panel convened by the TRA for the purpose of the regulation of teacher misconduct. And through this advice, it goes in detail as to the different allegations or different factual events which could lead to somebody falling within that definition. And in our submission, it's a very wide definition and quite all-encompassing. Page 378, my mistake, sets out the definition of unacceptable professional conduct. It states, unacceptable professional conduct is misconduct of a serious nature, falling significantly short of the standard of behaviour expected of a teacher. Misconduct outside of the education setting will amount to unacceptable professional conduct only if it affects the way the person fulfills their teaching role, or it may lead to pupils being exposed to or influenced by their behaviour in a harmful way. And paragraph 22 of that page also states about how the factors that need to be taken into account are the responsibilities and duties in relation to the safeguarding and welfare of pupils. So the TRA isn't just concerned with conduct, it's also concerned with protecting the safeguard and welfare of pupils. Yeah. In our submission, the DBS's function is very similar. It's been defined as inquiring and deciding whether or not a person should be included on the adults barred list or the children's barred list. And it's agreed that an individual should be included if it appears to the DBS that they have engaged in relevant conduct. And relevant conduct is set out at Schedule 341 of the 2006 Act, which is within the Bundle of Authorities at within tab 5, page 10. And this states the conduct, for the purpose of paragraph 3, relevant conduct, which is the conduct that is considered by the DBS, is conduct which endangers a child or is likely to endanger a child, conduct which, if repeated against or in relation to a child, will endanger that child or would be likely to endanger him. Conduct involving sexual material relating to children, including possession of such material. Conduct involving sexually explicit images depicting violence against human beings, including possession of such images, if it appears to the DBS that that conduct is inappropriate. And conduct of a sexual nature involving a child, if it appears to the DBS that that conduct is inappropriate. It therefore appears in our submission that any conduct that would fall within Schedule 3, paragraph 4 of the 2006 Act would also fall within the TRA's wide-capturing criteria of unacceptable professional conduct. It is difficult to see how, for example, 4A, endangering a child or being likely to endanger a child, would not be defined as unacceptable professional conduct. In our submission, the function of the two bodies, or their purpose, in this scenario, may be defined in different words, but their end goal in these circumstances is the same, to ensure the safety of children in school. And this is similar to the case of our Mandic Bozic, which you were referred to earlier, where res judicata cause of action estoppel was established, and at paragraph 2 of that case, it was stated
You say that case was rightly decided on that point?
In our submission, yes, we would say that it was rightly decided. At paragraph 2, it states that the standards of the two bodies may be expressed in different language by the two bodies, but they are nonetheless the same. And it therefore appears that the DBS and the TRA mirror the examples pointed towards in the case of Patel as factors that point towards privity. They are both public bodies and they are both charged with the protection of children in schools.
But just pausing there, if one goes back to Pottiwell, Mr. Justice Briggs, as he then was, found that HMRC and the Secretary of State were not privies, and he, in paragraph 20, and he said, it's precisely because those consequences are automatic and potentially far-reaching that the law should, in my view, be slow to recognise privity of interest between different persons. What do you say about that conclusion?
So, as my next point is how we can distinguish this case from Patel.
I've interrupted you too soon.
In Patel, a pointing away from privity in that case was HMRC has no power of its own to secure the disqualification of a director, whereas the Secretary of State does. And that was a factor that pointed away from them having the right.
That's the submission.
Yes.
So paragraph 18 is Mr. Justice Briggs recording the submissions that were made by Miss Graham Wells.
Yes.
Saying paragraph 19, and paragraph 20 is his conclusion. And one thing that clearly weighed significantly in his conclusion was the fact that the consequences are automatically and potentially far-reaching, and the law should be slow to recognise privity when the people are different.
Yes, and we accept that, but our submission is that when taking into account that all the factors of the Secretary of State and HMRC in favour of privity are made out, but also the submissions that were against it are in our submission made out in this case, it is a circumstance where privity should be recognised. So the submission was that the two bodies had different powers, whereas in this circumstance, both the TRA and the DBS have the same power to prevent teachers teaching in school. And secondly, another submission that was made against privity was that at paragraph 19, Miss Graham Wells relied upon the fact that HMRC could not, of its own motion, share information derived from the pursuits of its own functions with other government departments. In our submission, the TRA and DBS can share information, and this is evidenced throughout the information that's before the court today. So at page 34 of the supplementary bundle,
Yes.
There's
An example.
Yes, that's an example of the information sharing in that the TRA are writing to the DBS to alert them of the referral they've received and asking for any queries to be directed at the caseworker. And page 98 of the core bundle similarly gives an example within the final decision letter where it says we will inform the teaching regulation agency in confidence of our decision. And another example at 117 in the decision, an update was also sought from the TRA. To date, they have not made a decision in XYZ's case. So in our submission, it is clear that these two organisations share information, and there is in fact statutory provisions that allow them to do so. The final point in our submission today, pointing towards privity, is on page 50 of the bundle of authorities. Which is the point I read out earlier that says, I do not say that one must be the alter ego of the other, but it does seem to me that having due regard to the subject matter of the dispute, there must be a sufficient degree of identification between the two to make it just to hold that the decision to which one was party should be binding in proceedings to which the other was party. And the case of Patel states a very similar sentiment at paragraph 20 of that decision. Where it says, first, the question is whether the degree of identification of interest makes it just for the one to be bound by the outcome of proceedings about that issue involving the other, and bound regardless which way that outcome goes. Our position is, when considering the submissions my learned friend made earlier regarding Schedule 3, Section 16.3, which is that the opportunity to make representations does not include the opportunity to make representations that finding of facts made by a competent body were wrongly made, and that the DBS, by its own statute, recognises the TRA as a competent body. It, in effect, means that currently it appears that there is a sufficient degree of identification between the TRA and the DBS to mean an individual cannot make representations that are contrary to what the TRA has said to the DBS. Yet it can only be imagined that an individual would only wish to make those representations to the DBS that are contrary to the TRA when the TRA has found against them. So this therefore appears directly to conflict with the principles that were stated that the relationship of privity operates whether the decision is for or against the party in question. The situation in our submission that the TRA and the DBS find themselves in is that the situation operates effectively only upon the TRA having been successful, and by successful I mean a prohibition order having been made. And in that case, the individual who is subject to those TRA proceedings is bound not to make representations to the contrary of this. Whereas when the TRA are unsuccessful, such representations can of course be made. So if the TRA decides a prohibition order should not be made, representations to the contrary would clearly, if the TRA decides a prohibition order should be made, representations to the contrary are unlikely to be made by the individual. And it therefore appears in our submission that the DBS and the TRA join together when the TRA finds a prohibition order should be made, but not in the contrary circumstances.
Sorry, they join together. How does that work?
Join together is probably quite loose language. I mean that the individual cannot make representations that go against what the TRA says to the DBS.
But that's what Parliament said.
Yes, of course, but that only really works to a negative to an individual, because they wouldn't want to make representations against the TRA if the TRA said a prohibition order isn't going to be made.
But that's what Parliament's decided. How can we go against that?
No, we're not. In my submissions, I'm not saying we should go against that,
Right.
but I'm saying it points to the fact that at the moment, privity in a wide sense only seems to work one way, in that the individual is bound by what the TRA says in the representations they can make, but they wouldn't want to make any other representations if the TRA says that that a prohibition order isn't required. So in our submission, the TRA and the DBS do therefore have a sufficient degree of privity, and for that reason, our submission is that res judicata cause of action applies, and the DBS were not able to litigate in the way they did. Unless I can assist further, those are my submissions, and that is the case for the appellant.
I do have one question, please. There's quite a lot of case law about estoppel in public law, which I'm not sure either side has really latched onto. And the general trend of the cases is that there isn't such a doctrine in public law. And I think we might be helped by some submissions on that case law, because the submissions you've been making are all about private law. I mean, I accept that the decision we've been looking at about Mr. Pottiwell has aspects of both, but Gleeson and Whipple, for example, is about a private law cause of action for breach of copyright.
So it would assist the court if the public law aspect was examined more closely.
Well, I think it would help me.
Well, we're not really in public law territory, though, are we? Because we're dealing with professional discipline, but there's no question of JR or anything like that. I suppose to the extent that we're dealing with a public body, we might be.
Well, I think we are more in that area than we are in private law, and I think it might help just to have a full picture of the case law.
Well, maybe what we should do is rise for a minute or two to discuss where we've got to before we call on Miss Broadfoot, if that's all right. Yeah. So we'll just rise for a few minutes. That's fine. think, Ms McLaughlin, we'll park the question of whether or not we could do with some more assistance from counsel on questions of estoppel in public law until we've heard from Ms Broadfoot, and then once we've heard the full argument, we'll revisit that at the end of the day. Yes, Ms Broadfoot.
Thank you. I appear along with my learned junior, Barney McKay, who wasn't introduced at the beginning, so I do so now.
Just about been introduced now.
Thank you. The approach that I'm going to take is I'm going to deal first with ground 1, then I will deal with Privy's point, which I know is ground 4, but it seems to me sensible to deal with that first, and then we'll go on to the unfairness abuse doctrine. So in terms of ground 1, can I first start by raising an issue about the scope of the ground of appeal? At page 18 of the core bundle sets out the actual ground itself, and the challenge, that's the ground of appeal, page 18, and the challenge itself is to paragraph 64 of the Upper Tribunal's determination on the basis that the Upper Tribunal have misunderstood or misinterpreted the scope of its jurisdiction under Schedule 3. So that's the ground of appeal, ground 1, page 18 of the core bundle. Now the title of ground 1 goes a bit wider than that. It says significant weight to be applied, etc. So if one then looks at the skeleton argument, which is at page 24 of the core bundle on this point, you can see that once again the focus of the challenge is on paragraph 64 of the Upper Tribunal's determination, that's paragraph 27. On the grounds, paragraph 28, that the Upper Tribunal misunderstood or misinterpreted the scope of their jurisdiction. And then there's a whole section in the middle that's now irrelevant because that's to do with Hansard, which has not been permitted to be run. And then if you look at paragraph 36, the conclusion is Parliament did not wish for the DBS to replicate work, and the process would intend to be one of information sharing and an atmosphere of collusion, and but reference back to paragraph 16. So that's actually the argument that we've responded to, which is focused on that. So can I start then with relevant parts of the statutory scheme without taking you through all of it? But if one turns to tab 5 of the authorities bundle, page 8, this is paragraph 3 of Schedule 3, and subparagraph 3, the DBS must include the person in the children's barred list if A, it is satisfied the person is engaged in relevant conduct, AA, it has reason to believe that the person is or has been or might in future be engaged in regulated activity relating to children, and B, it is satisfied it is appropriate to include the person in the list. Yeah. And then relevant conduct is defined at page 10, on page 10 of the bundle. It's paragraph 4 of Schedule 3, and there's the list in subparagraph 1 that you've already been taken to by now and just now. Yes. If I was you then to skip ahead, and we'll come back to paragraph 6 in a minute, but if you skip ahead to page 16, which is also paragraph 16 of Schedule 3, this is the provision that deals with certain procedural matters. Now, it's not in dispute, and we can find the necessary parts if required, but the legislation requires the DBS in this type of case to give the individual an opportunity to make representations before a final decision is made. Yeah. And that's why the process is you have a referral to the DBS and potentially another regulatory body, and then you have initial sort of minded to consideration and a minded to bar letter if that's the
It's a standard form of procedural
Exactly.
unfairness or fairness provision. The opportunity to make representations before something is finally decided by the DBS. And the curiosity of this case is that the regulator doesn't make the decision before the DBS does. So in this particular case, the DBS decision, as you rightly pointed out, came first.
by you.
So at that stage, you would say Schedule 3, this paragraph doesn't kick in at all.
It doesn't, but to be fair, Malone Friend was not saying
No.
that it kicked in at the DBS consideration stage, because that would obviously be a nonsense, because there was no competent body decision at that point.
No.
But what he's saying is that it must be relevant to the approach by the upper tribunal when the matter goes on appeal, if it happens in between. That's my understanding of the submission.
Yes.
And our short answer to all of this is that paragraph 16 is of no application to what happens in the upper tribunal, because it is simply paragraph 16, subparagraph 3 is a limitation on the representations that can be made to the DBS before the initial decision.
Yeah.
And so that begs the question as to, well, why is it so? Because, of course, the argument made in the skeleton and touched on today in oral argument is, well, that would be very unfair. You know, it must indicate that competent bodies, of which there is a list, are viewed by Parliament to carry special weight in their decisions, and therefore it should be binding in both directions.
You say what it does is actually ensure that the DBS doesn't get involved in what is effectively an argument that would be raised on appeal in relation to a competent body.
Exactly.
The competent body, there is a particular statutory route of appeal for challenging the decision.
Yes.
Get that completely, but can I ask you this then? Let us suppose, different case from this.
Yes.
Same complaint is made to the DBS and to the Teachers Regulatory Authority.
Yes.
Regulatory Authority decides the matter itself, and the DBS holds off its decision until the Teachers Regulatory Authority. And the Teachers Regulatory Authority makes a lot of adverse findings to the teacher.
Yes.
Teacher can't, under the schedule, challenge that before the DBS, but can to the High Court.
Yes.
Teacher gets permission to appeal, goes to the High Court. High Court says Teachers Regulatory Authority has got it all completely wrong. Now, it may well be that the DBS hasn't yet decided. That might be a bit artificial, but let's suppose they parked it until there's the exhaustion of the appeals process. What's the impact of Schedule 3, Para 16 on the appeal decision?
So, on the appeal decision to the High...
Yes, the High Court says the regulator has got it wrong, and therefore there is now the backing of the High Court for saying that the regulator has got it wrong. Is the teacher still precluded by this schedule from saying the regulator's got it wrong?
No, because there is one of two routes. Either it would be by statutory appeal, in which case the allowing of the appeal would quash
the decision. So there is no decision.
So there is no decision. Or it would be by judicial review, in which case, again, the remedy would be to quash the decision, and there is no decision.
Yes. Okay. And would the same analysis apply if the DBS makes its decision in line with the original decision, and that decision is then reversed by the High Court before you go to the Upper Tribunal? So the Upper Tribunal now has a quashing decision.
So there are two answers to that. And it depends partly where somebody might be in the proceedings. In the proceedings in relation to the DBS decision, because of course we're talking about parallel proceedings here. One option would be that there is the power to review. So one might think it was quite a strong case to apply, to ask for a review, and the DBS, having accepted all the adverse findings that have been made, let's say, they would then have to revisit all of that, because that may well be a significant change of circumstances. So there are the review powers, and equally, which can be exercised, by the way, after the decision but before an appeal is heard.
Yes.
So there's no.
Is there any time limit or anything
There's
like
no,
that?
there's no time limit, and nor is there a procedural place where that must happen, or rather a place where it can't happen.
Right.
So it can happen at any point if the relevant threshold for obtaining a review is met. It doesn't matter where a person is in the system.
And in some ways a much easier route, because presumably it can be done in writing. You just send in the decision of the teaching body and
that's right.
Ask them to look at it again.
So it's para 18 of Schedule 3, the review process, I think.
Yes, I think that's right. We have paragraph 18 already.
And the review can be made within the minimum barred period.
Oh, but that is
3A, which is defined in 6.
That's to do with certain types of barring which follow on. I'll need to check this, and I'll check it over lunch.
Yeah.
I think that's to do with certain barrings following serious convictions have a minimum time period before a review can be requested, because if they're automatic barring cases. I don't think that's entirely right, because I'm not getting a big nod, but I will check that over lunch.
Yes.
But there are
certain consequences that flow from certain convictions, you
Correct.
say, statutory.
exactly.
But in principle, you can ask for a review before there's an appeal heard.
That's right. And so, and then, so that was the review is the one answer.
Is one answer, the
and
other
then
is
in
the
relation to the appeal process in front of the Upper Tribunal, there would be no decision.
Yes, it's the same point.
And it's the same point. The Upper Tribunal can accept new evidence. It looks for a mistake of fact or a mistake of law, but it can do so on the basis of post-decision evidence. And so,
is it bound by the decision of the High Court in those circumstances?
I'm sorry?
Is it bound by the decision of the High Court in those circumstances?
Is the Upper Tribunal
Yes.
bound by this? No.
Why not?
Well, it depends what you mean.
Well, let's suppose that you've had a decision of the tribunal which evaluates the evidence and does various things, and the High Court then says it wasn't entitled to reach those conclusions. The evidence actually shows something completely different, and the tribunal was completely out of order, and quashes it. There are a number of ways in which the High Court could deal with it. You see, the High Court may not substitute its own findings of fact. It may send it back to the tribunal for another hearing, presumably.
Yes.
Particularly if it's a judicial review, that's what you'd normally do.
Yes.
So at that point, you've got no decision. What then happens? Does the Upper Tribunal look at the matter in a vacuum, or does it give such weight as it thinks appropriate to the High Court? I mean, how do the two work together on your submission?
Sorry, I'm very, very reluctant to interject. It's just simply that what my learned friend has not said to you is not strictly correct. If one looks at page 100 of the bundle, in respect of the review system, XYZ could only make a request for a review after 2030.
So it's
Core
after
bundle.
the period.
Yes.
Oh.
So where
I
are
thought
we?
you accepted he could make an application for a review.
It says on the letter.
Well, sorry, which page?
So 100 of the core bundle.
Core bundle.
100, right.
Well, I think that's one point that the two of you need to both check over the lunch
Yes,
period.
I think we will.
If there's controversy about it, so that we get an agreed position if possible.
Yeah, my learned friend is absolutely right. That's what the letter says. Let me please check that over lunch.
It's rather
Thank
important,
you,
isn't
Mr.
it?
No, absolutely.
I think it is, yes.
Might it just be? I realise it's 5 to 1, but could we just perhaps just stop?
Yes, maybe
5
that
minutes
would be a
early?
convenient moment, and then we're doing well for time, I would have thought. So
I think so.
I don't think there's no danger of us overrunning today. So that's
No,
fine.
thank you.
Right, shall we say 2 o'clock?
I think there must be some regulations which are relevant to the minimum bar period, which we perhaps haven't got if one looks at paragraph 18, subparagraph 6, schedule 3.
Yeah.
She said unhelpfully.
which we haven't got. 2 o'clock.
Thank you.